The corruption trial of former President Jacob Zuma is set to resume in the High Court sitting in Pietermaritzburg tomorrow. The trial will be held virtually, connecting to Zuma at Estcourt prison. That's where, as you know, he's serving his 15-month sentence for being in contempt. The first item will be an attempt, if you like, by Zuma's legal team to have Prosecutor removed. For more on what to expect, let's bring in legal analyst Mpumelelo Zikalala, who joins us now via our video link. Bub Zikalala, always great getting your insights. Thanks very much indeed for making time for us here on Newzroom Channel 405. So perhaps let's begin with the issues outside court that have been ventilated in the last, 48, 72 hours or so. The Jacob Zuma Foundation, among those in society speaking out against these proceedings being held virtually, the thrust of their argument is that it's unconstitutional because an accused needs to be present during a trial. Do they have a point, or is this a selective interpretation, if you like, of the law?
Good afternoon to you and also to your listeners. Strictly speaking, they are quite right. However, if we look at the Criminal Procedure Act, which is a manual that tells us how do we conduct ourselves during proceedings, it does allow in certain instances, if you look at Section 158, that certain proceedings can be held virtually. However, we must be specific on this one. A trial in which a witness will have to give witness, obviously on that one it wouldn't be allowed, unless it is a sexual offense or it fits in within the ones which are described within the Sexual Offences Act. Now, we've got to look at the context of what is happening tomorrow. Now, tomorrow, it's a, call it a side issue or a point in limine, detailing with the right to prosecute of Advocate Billy Downer. So the question that they would need to ask, or that the court would need to deal with, if an application which would come up tomorrow is, will the former president give evidence? Is there anyone who's going to give evidence on the day? Is there going to be a need of cross-examination which is going to take place? But most importantly, is there going to be a need for instructions to flow from the former president to his attorneys? If that is the situation, that they may have a point in terms of saying, we can't provide a trial of this magnitude, of these instances virtually, because I need to be in constant communication with my attorneys. However, if it is a point of interactions between the legal practitioners, there is no evidence which is going to be led. They are simply going there to argue on a point of law, similar to what they did a few weeks ago in the Pietermaritzburg High Court. Then the court will tend to lean to the side of saying, why engage in unreasonable delays when your client is not going to give evidence? In fact, there's no other person who's going to give evidence. Let's carry on with these proceedings because we are mindful of the time that is taking place in order for us to start and complete this particular matter. Yeah,
part of the court substantiating this call for a virtual hearing because of the mood in the country, for lack of a better term. I mean, many people might see that as the court being influenced by outside development. Again, would that be a fair reading of the situation or a bit of a stretch?
But maybe another point would be the court then says we can't be oblivious to what is happening outside, but you also have to take the safety of the court buildings themselves, one, of the officials of the court, secondly, into consideration, and what is happening outside. I would tend to worry if the decisions of the court are influenced, but if it's just mere processes such as these ones, then I wouldn't worry and say our courts are being influenced. For now, it is purely a precautionary measure. They are simply saying, in line with the Act, we want to avoid unreasonable delays, we want to save costs, we want it to be the convenience sake, and it is certainly in the interest of justice and public safety that we hold these proceedings virtually. There is no harm which is going to be suffered, and if any of the parties are going to suffer harm, they are more than welcome to make representations at court, and the court will consider that.
Sure. Of course, at the heart of tomorrow's virtual gathering, potentially, is Billy Downer and the challenges to him as the state prosecutor in this matter. Jacob Zuma's lawyers arguing, I think it's Section 106 of the Criminal Procedure Act being at the heart of their argument. Essentially, Billy Downer being accused of a whole host of things, including being biased and leaking information to journalists. At what leg of this part of the trial are we likely to ventilate tomorrow? And more importantly, do you imagine that chapter being closed tomorrow?
We can almost call it a point in limine, like a side issue of saying, let's get over this hurdle before we deal with the crux of the matter. So they're basically saying, we want to extend the interpretation of the title to prosecute, not only to administrative processes, where you are allowed by the minister or whoever is employing within the NPA Act to prosecute. We want to extend it and say, Due to your conduct, you have engaged in certain things in which you have assisted private individuals, probably given them insider information as while you are still employed in the NPA. There are certain contraventions that you may have done in terms of maybe Section 30 of the NPA Act or Section 25. It was improper of you to depose to an affidavit of a private individual because you so wanted to prosecute the former president. Now you have achieved that and you don't believe that you are going to be impartial. So what the former president team is seeking to do is to say the court must extend the interpretation of the no title to prosecute even to the conduct of the prosecutor so that at the end of the day a fair trial can be seen to be given. I must say though, it's going to be a bit of a mammoth task because we have decided case law when it comes to this particular point. If we look at the case of Porret versus the NPA, the court was very clear in terms of saying what you are coming to ventilate here and saying that a person has no charge to prosecute cannot succeed. In fact, what you should do, seek to protect your rights using Section 35 of the Constitution, and you can raise any other issue that you may feel that the prosecutor was biased towards in appeal processes. In that instance, your Section 322 or the read to 319 will then come into effect, and you'll be able to protect the instances or the rights of your clients. However, to come at this particular stage with that would be a problem. But I must mention this and place it on record. The circumstances here are a bit different. We have an active participation of an NPA official or a senior prosecutor in private individuals' affairs. They may come up with a defense of saying that, can you please protect me in terms of the Protected Disclosure Act? I needed to act in that particular instance. The situation at that time, I as Advocate Belitano was not conducive. So I needed to act in order to preserve justice. However, all of that will be ventilated tomorrow, and it will be a mammoth task for the court, maybe let's say for the Jacob Zuma team, to prove that the interpretation of the no title to prosecute must be extended to the conduct of the prosecutor outside the bounds of his work.
So simply put, we're unlikely to see the end of this leg of the court proceedings tomorrow.
If because they do have an option of saying, if we fail tomorrow to deal with those issues, we want to go to the Supreme Court of Appeals. We can even go to the same court with the full bench this time, Supreme Court of Appeals to the Constitutional Court before you start with the actual merits. So you may see a projected sort of fight pertaining with this point in limine before you move on to the crux or the merits of the matter, or actually to the pleading of the case if we move on that direction.
Sure. Not to be, I guess, disjuncted in my connection of the different issues at play here, but it's also difficult to ignore the reports that Zuma's lawyers actually might even be arguing for postponement tomorrow. But at the heart of that is this matter of this being heard virtually. Very quickly, your prospects of success on that issue?
I think they'll have to, it will depend on the circumstances or their submissions. If you come to court and say, I need to be able to take instructions from my client, so they need to be close with me, there's going to be viva voce evidence which is going to be provided at a later stage, either from my client or from any other person. It is not a question of dealing with affidavits here and information or submissions which are on paper or that are going to be argued. There's evidence which is going to be provided by actual witnesses going into the witness box. As the court, you may have in theory powers to say that, however, this Criminal Procedure Act does not give you absolute power to do that. So we want an opportunity to have our client inside the court to be able to give us instructions pertaining to the circumstances of the matter. But if it's going to be an instance where arguments are purely made, submissions have been done, affidavits have been drafted, all heads of argument have been submitted, then I do not see the court saying to them, yes, we do agree with you. The court will say, let us look at the intention of what we are doing here. We want this case to start and end within the shortest amount of time. We've given you ample amount of opportunity to submit your papers. It is only the argument stage, similar to what you did previously. And if your client seeks to give you instruction at any particular point, they are free to raise their hand and say, can I speak with my attorney either through the phone or in a private conversation type of setting, and you'll be able to continue. But the most important thing is that this trial must be able to proceed efficiently, and you must be able to deal with these matters. It's been a long time coming, and you can't afford any postponements anymore.
It's, of course, also very difficult to ignore how the optics have changed since this matter was in court. For one, the former president is now an incarcerated man, albeit on a very different and separate matter. One can't help, though, but imagine if to imagine if in any way he's being an incarcerated man might have a bearing on this particular case. One hopes it doesn't, but is it inevitable?
It is, because they would then say, you know, if our client was a free man, would be able to consult up until the wee hours of the morning or at any particular point in time. Any other issues that would crop up at any time, we'll be able to discuss with them, get proper instructions, and we're able to represent him. However, if we want to speak with our clients now, we have to go through the whole bureaucratic process. We have to travel to Estcourt from Johannesburg or from Durban or forever. So it does impede on our accessibility and our level of preparedness when dealing with this type of cases. So it can work in their favor in terms of saying, can you please understand where you are coming from? These are the difficulties that we may have. In fact, it adds to the argument earlier of saying, we may not have proper instructions because we're only given a limited amount of time to consult. We're not given the whole day at Estcourt prison. So for us, there are certain issues which are going to be raised from the floor, and we can't do that due to our client being in Estcourt, and meanwhile we're in Pietermaritzburg. So allow our client to come here. There will be no harm that's going to be suffered by any other parties. But the courts will have to be sort of strict on this matter and say what is in the interest of justice. The protection of the rights of the accused are paramount. At the same time, the efficient running of the court system and finalizing of the matter within the shortest amount of time, which is also paramount. So it's the balancing act of the two.
Sure. Plenty of moving parts. Thanks very much indeed for helping us get some kind of perspective of what to make of them. Mpumelelo Zikalala is a legal analyst. Thanks very much indeed for your time. All right, in just a moment, we'll continue with that discussion, get you a sense of what else we should think about in the lead up to the former president's incarceration. Plus, of course, to the former president's corruption trial, I beg your pardon.